It's all slavery, blah, blah, blah. And he's like, I love the system. In one instance, I was like, man, for being the most brilliant motherfucker I've ever met, that was the dumbest thing I've ever heard come out of your mouth. He's like, I fucking love the system. I love the IRS. I love the system. And I'm thinking to myself, what the fucking, something happened to you? You fucking coconut fell off and hit you in the head or something? What the fuck's going on? You sick? No, I love the system. I fucking love it. And I remember what my first mentor said: as soon as you figure this out, Derek, you're going to have a fucking blast. Well, Smoking Baby had already figured it out. He's having a fucking blast. And I couldn't figure out why he's always giggly and laughing when people are like, oh, we should abolish the IRS and fuck the IRS and all this stuff. Listen to what is being said here. The words, the beginning of the war, as used herein, shall be deemed to mean midnight, ending the day on which Congress, what's Congress in control of again? Legislative branch, right? And the president answers to who? Congress has declared or shall declare war, or the existence of a state of war. Didn't they declare war on agriculture, war on drugs, war on homelessness, war on poverty, war on education, right? War on pandemic. The words end of the war, as used herein, shall be deemed to mean the date of proclamation. Wars start with a declaration, they end with a proclamation. Abraham Lincoln was euthanized before he could end the war by way of proclamation. The letter of the law is specific. Words have power and they have meaning. There was no proclamation that ended the war. Therefore, the war has been perpetual since what, 1812? Perpetual ongoing war. All right. End of the war, as used herein, shall be deemed to mean the date of proclamation of exchange of ratification of the treaty of peace, unless the president shall, by proclamation, treaty declare a prior date, in which case the date so proclaimed shall be deemed to be the end of the war within the meaning of this act. Does an act replace and abolish and amend the Constitution or the amendments? Does an act replace the Bill of Rights? No.
No.
Okay. Pay attention. This is the creation of their trust. You got the Federal Reserve Act of 1913 that was contrived in 1910 and planned probably 50 years prior to that. And in 1917, which is, anybody know their history? World War One, right?
Yeah, Russia.
World War One. We have allies like France and everybody else, right? The words bank or banks, as used herein, shall be deemed to mean and include national banks. Wait a minute. Congress never had the authority delegated to them in the Constitution to create anything. No national banks exist. So look how they're coloring everything. This is their trust. This is the trust indenture. They're defining things. They're telling you how it works under military occupation. This is why you have that indemnification certificate, and I'm going to prove it to you, which is known as the birth certificate, a bill of lading, a warehouse receipt, evidence of a very large fucking debt. The words banks or banks, as used herein, shall be deemed to mean and include national banks, state banks, trust companies, or other banks or banking associations. See, there's banking associations and affiliates, but there are no banks here. There's no banks in the United States, and there's no banks in the several states or the Union of States. Doing business under the laws of the United States or of any state of the United States. The words to trade, as used herein, shall be deemed to mean A, pay, satisfy, compromise, or give security for the payment or satisfaction of any debt or obligation. To trade, as used herein, shall be deemed to mean pay, satisfy, compromise, or give security for the payment or satisfaction of any debt or obligation. D, draw, accept, pay, present for acceptance or payment, or endorse any negotiable instrument or chosen action. C, enter into, carry on, complete, or perform any contract, agreement, or obligation. D, buy or sell, loan or extend credit, trade in, deal with, exchange, transmit, transfer, assign, or otherwise dispose of, or receive any form of property. Did they trade with you? Do you have something of value? Is
No.
a is a receipt, does a receipt carry value? That birth certificate is called the warehouse receipt for a fucking reason. They're telling you what trade is: to pay, satisfy, compromise, or give security for the payment or satisfaction of any debt or obligation. They're telling you what it is. Is it any wonder why when you go into the bank, which they proclaim to be a court, and you release your beneficial interest you may have in that certificate? What's another word for certificate? Security.
Title.
Security. It could be a deed, but they cover it because they also say, or otherwise dispose of or receive any form of property. Is title a form of property?
Any
Really?
interest in, yep.
Absolutely. You got general tangible, general intangible, right? To have any form of business or commercial communications or intercourse with, acts unlawful, trading in United States with enemy or ally, or for benefit thereof without a license. Wait a minute. They're telling me that I have to have a driver's license? So I must be an enemy, right? According to their logic here. For any person in the United States except with the license of the president. Now, how in the fuck, if he's only the president of the United States, am I required to acquire a license from him who only has control over federal territory, land ceded to or owned by the United States? Hello?
The
Any
birth
answer?
certificate is land.
Where did they get the jurisdiction? They presumed they
did.
assumed it. They put it
Yeah.
out there on the boob tube and people ate it up, gobbled it up like chocolate covered fucking turd. Granted to
Conclusive
such
presumption.
person, granted to such person or to the enemy or ally of the enemy as provided in this act, to trade or attempt to trade, either directly or indirectly with, to, or from, or for, or on account of, or on behalf of, or for the benefit of any other person. Person is not people. That's juristic. With knowledge or reasonable cause to believe that such other persons, they only deal in the fiction, is an enemy or an ally of an enemy, or is conducting or taking part in such trade. They only have to believe, by the way. Believe that such other person is an enemy or ally of the enemy, or is conducting or taking part in such trade directly or indirectly for, or on account of, or on behalf of, or for the benefit of an enemy or ally of an enemy. Transporting enemy or ally to or from United States without a license. For any person except with the license of the president to transport or attempt to transport into or from the United States. Remember, the United States that's the egress that is the import and excise tax. The United States is 10 square miles. All right. And the land owned by or ceded to the United States, or for any owner, master, or other person. Funny how they say master. That's because the birth certificate is evidence of the birth estate, and the birth estate is a domestic trust, is a United States vessel, is a United States citizen, and is a United States debtor, or other person in charge of a vessel of American registry to transport or attempt to transport from any place to any other place, any subject or citizen of an enemy or ally of an enemy nation with knowledge or reasonable cause to believe that the person transported or attempted to be transported is such subject or citizen. For any person other than a person in this service of the United States government, guess what? When they're taking in the Article 1, Section 8, Clause 9, military, private, special star chambers, tribunal outside the jurisdiction of the judiciary because they didn't take the Article 6 oath, ladies and gentlemen, they are presuming and assuming that you are a member of the militia and subject to their legislative edicts. It's a presumption and assumption. It's prima facie evidence because you got all these applications that create minimal contact doctrine where you're in presumed and assumed by your joint business ventures with them to have capitulated and become subject to them. United States
Hold on,
government.
Derek, hold on 1 second, please. Let's stop this. 10:35 mark. Hold on 1 second, please. Okay, 10:35 time mark. Go ahead. Thank you so much.
Or of the government of any nation except that of an enemy or ally of an enemy nation, and other than such person or classes of person as may be exempted. There you are, right there. That's you. You are a class of person as may be exempted hereunder by the president. Are you ready? Now I'm going to show you where you're exempted. All right. Well, let's go further so we don't miss anything important. By such person as he may direct to send or take out of or bring into or attempt to send or take out of or bring into the United States any letter or other writing or tangible form of communication except in the regular course of the mail, and it shall be unlawful for any person to send, take, or transmit or attempt to send, take, or transmit out of the United States. Remember, geographically speaking, the United States is 10 square mile area, and the military forts, arsenals, and bases, and the national forest. Any letter or other writing, book, map, plan, or other paper, picture, or any telegram or wireless message or other form of communication intended for or to be delivered directly or indirectly to an enemy or ally of the enemy, provided, however, that any person may send, take, or transmit out of the United States anything herein forbidden, if he shall first submit to the same to the president or to such officer as the president may direct, and shall obtain the license or consent. Wait a minute, I thought it was consent to the governed. All of a sudden, we've got to consent to them. We got to capitulate to them. Consent of the president under such rules and regulations and with such exemptions as shall be prescribed by the president. Whenever during the present war, the president shall deem that the public safety demands it. Again, they're doing everything under the guise of safety. Remember, Cool Fox was telling you that. All right. Remember, also, Rick Martin was telling you that. They're doing everything under safety because they can't prove territorial jurisdiction. So their next reach for everything is going to be under the guise of safety. He may cause to be censored under such rules and regulations as he may from time to time establish communications by mail, cable, rail, radio, or other means of transmissions passing between the United States and any foreign country. He may from time to time specify, or which may be carried by any vessel. Remember, the birth certificate is a United States vessel. The Social Security juristic person is a United States vessel. They are United States debtors. They are domestic trusts or other means of transportation touching at any port, place, or territory of the United States and bound to or from any foreign country. Any person who willfully evades or attempts to evade the submission of any such communications to such censorship or willfully uses or attempts to use any code or other device for the purpose of concealing from such censorship the intended meaning of such communication shall be punished as provided in Section 16 of this Act. Now, I'm going to skip down here because the important part is right here. Now, back in the day, there was a guy who took a birth certificate out of the country, and he was enticed by a foreign banker, and the foreign banker convinced him that if he brought um, an authenticated United States birth certificate into the country, into a foreign country, that he would negotiate it for him for a significant amount. That man ended up in prison for a period of 30 days after the passage of the act, the further pending the entry of such order by the president after application made within such 30 days by any enemy or ally of the enemy other than an insurance or reinsurance company as above provided, it shall be unlawful for such enemy or ally of the enemy to continue to do business in this country and for any person to trade with, to, from, for, on account of, on behalf of, or for the benefit of such enemy or ally of the enemy, anything in this act to the contrary notwithstanding, provided, however, that the provisions of sections 3 of and 16 shall herefore shall apply to any act or attempted act of transmission or transfer of money. What's a security again? Oh, that's right. It's money under the new
Oh, yeah.
law. Or other property out of the United States and to the use or attempted use of such
It is.
money or property
It is.
as the basis for the
Sorry, it is.
establishment of any credit within
put it
or
back.
outside of the United States
I'll be
to
fine.
or for the benefit of
Someone take
or
my
on
shit
behalf of or on account of an enemy or
Gotta write shit
ally
down
of the
for
enemy. When that guy took his birth certificate authenticated outside
I
of the
gotta
United
go. I
States,
cannot listen. I can't hear.
you guys got to mute out. Holy Pete. I don't want to have to, good lands. I don't want to have to mute everybody. When that gentleman authenticated his, the birth certificates, and he was promised by a banker in another country that if he brought him the birth certificates, he would monetize them for him. When he did that, he was charged up with taking United States securities out of the United States, and he was charged with securities fraud. So tell me the birth certificates, the warehouse receipts don't have value. They do. This Trading with the Enemy Act, again, is the trust indenture for how they function. But I'm going to show you something really, really, really cool. I just got to find it. Alien property custodian. Authorized. Now, the alien property custodian is now the Foreign Affairs Office at the Treasury. Okay, it's been moved over there, but your Solicitor Generals, known as your Attorney Generals, still are physical agents of the Treasury. So we're going to skip the Trading with the Enemy Act because I want to go to right here, Section 7. And we are going to go to E, corporations, transmit list of stockholders, etc., believed to be enemies. List of stock on February 1917. Where is E at? Where did it go? A, B, C, D, E. All right. So remember, we were talking about how you can go into a courthouse, which is really a bank, and you can release your beneficial interest that you may have in this certificate to render, settle, and close the matter. And people really don't understand why it works. It's because we're in military occupation under martial law. But I'm going to show you where you've been indemnified. No person shall be held liable in any court for or in respect to anything done or omitted in pursuance of any order, rule, or regulation made by the President under the authority of this act. No person shall be held liable in any court. That means Article 1, Section 8, Clause 9, or the Article 3, or Article 3, Subsection 2, Subpart 1. No person shall be held liable in any court. Why? Because they're tax courts. Remember, they're in charge of excise taxes. These are all tax courts. They're telling you right now, no person shall be held liable in any court for or in respect to anything done or omitted in pursuance of any order, rule, or regulation made by the president. Didn't the president create Executive Order 2039, 2040? Didn't he sign off on 40 Statute at Large 411, Section 7E? In the 73rd Congress, First Session, Volume 77, Part 1, didn't he also sign off that the new money is notes, drafts, bills of exchange, banker acceptance, trade acceptances? that are then lent to the bank, and the bank then takes them to the federal discount window or negotiates it with the comptroller of the currency for Federal Reserve notes that are used for bank-to-bank transfers and no other purposes are hereby authorized?
Yes.
So how in the fuck are you being held accountable for counterfeiting when you write a negotiable instrument on a closed checking account? How are you being charged with that?
This has also been this has also been recodified under Title 50, Section 4032, Part 2A, I believe.
Yeah, it's 504305 B2.
Yeah,
But
B2. Thank
but
Because every
it was
bank is
formally
a PMA.
it was
Every bank's a PMA, that's why.
it was formerly Title 1295A, and then they repealed it and stuck it at Title 504305B2. But Title 12, United States Code 95A, you guys have to understand that that's not directly from the archivist. That's paraphrased. That's more of a guidance reference. If you want the actual law, you need to do what I'm doing, and you need to look at the
Absolutely.
hard.
Absolutely. This is the matrix. This is the foundation of it all.
Title
Yep.
504305B2 in USC is paraphrased. It's a third party that creates that jargon. I use it more as reference guides where it kind of tells me what the statute at large may or may not say, but not verbatim. It gives me an idea. But knowing how they operate under deception, false and misleading and deceptive trade practices, I would never rest my hat on the United States Code. And here's why. United States Code applies where? Applies to who? Applies to what?
Fictions.
United States Corporation.
No, it applies to the municipality
And the
Washington,
volunteers.
D.C., the District of Columbia. What the fuck's that got to do with us out here? See
All
that?
fictions.
Made by the president under the authority of this act. Any payment, conveyance, transfer, assignment, or delivery of money under the 73rd Congress, First Session, Volume 77, Part 1, why they had to go into an emergency meeting March 4th through March 9th and extend it by 3 days from the 6th to the 9th, was because what Congress did was violate the Fourth and Fifth Amendment by taking our property without just compensation and due process of law when they took gold and silver from us. Okay. That was a breach. All right. And then to add insult to injury, they decided they were not going to honor their obligations, but yet still tell us that we had a duty to uphold our end. So the new money under the 73rd Congress, First Session, Volume 77, Part 1, directly correlates with this. This is preemptive, guys. They set this up knowing full on well what they were going to do in 1933, and this is clear back in 1917. And to prove my point, none of this has changed since 1917. Money or property made to the alien property custodian hereunder shall be a full acquittance and discharge. Alien property custodian at one point was the attorney generals. The attorney generals are physical agents of the Treasury. So in a lot of parts, the alien property custodian is still technically the attorney general. What's interesting about that is when you do the research into the solicitor generals, which is what all these Article 1, Section 8, Clause 9 venues have to have permission. They have to have their delegation of authority, their letter of appointment, their grant of assignment to operate outside their 10 square mile area from the Solicitor General. Guess who the Solicitor Generals are in all 50 states? Your Attorney Generals. Isn't that funny? Now listen to what it says. And you have county solicitor generals and you have city solicitor generals, but they all answer to the Attorney General of the state. No person shall be held liable in any court for or in respect to anything done or omitted in pursuance of any order, rule, or regulation made by the president under the authority of this act. Any payment, conveyance, transfer, assignment. What do the banks do all the time? That's right. They make assignments. And average people read that and they go, oh, they just made an assignment. No big deal. No, they took your private intellectual property. They hoodwinked you out of it. And when they say assignment, they pledged it into the future and ledgered it and lodged it for a return on investments. That's why all your contracts say you agree to give us our and we your rents, profits, proceeds, futures, and annuities.
Added it to their balance sheet, and we don't even know what a balance sheet is.
Double bookkeeping entry or delivery of money or property made to the alien property custodian hereunder shall be a full acquittance and discharge. Don't they tell you that the only way that you can take care of things is through acquittance and discharge? Have you ever beat a court case? What does it say? It says acquittance or dismissal, right? But they never circle acquittance or dismissal. They just leave both words on there. It's acquittance or dismissal. Which one is it? And what's the difference in the connotation between a discharge and an acquittance? Discharge just kicks the buck down the road, right? The Buck Act. What is an acquittance? And is there something here if you have an acquittance? Is an acquittance kind of like an acquisition? Is there something that you're abandoning when you get an acquittance out of a bank, which they masquerade around as courts? Is there abandoned property here? For all purposes of the obligation of the person making the same, to the extent of the same. Now, up above, we found out that payment means what? Did you guys forget it already? We'll go back up there. The alien property custodian and such other persons
To trade.
to trade. That's right. So when I'm releasing my beneficial interest in said certificate, right? Are we making a trade? Even exchange for a trade? When I give that
Yes.
citation on the side of the road and he wants my signature, are we making a trade? Value for value, right? Such other person as the president may appoint shall have power to execute, acknowledge, and deliver any such instruments or instruments as may be necessary or proper to evidence upon the record or otherwise such acquittance and discharge. Pretty odd. And shall, in cases of payment, what's payment again? See, what you're doing at the car dealership is an acquisition. It's paper for paper. The actual automobile is a consolation prize. It's to entice you. It's the shiny shit to get you to come in the door. Because what they want is paper for paper. You're engaged in trade, and trade is payment. Case of payment to the alien property custodian of any debt or obligation owed to an enemy or ally of the enemy, deliver up any notes, bonds, or other evidence of indebtedness. What's a receipt? Is that evidence of indebtedness? What's a warehouse receipt? What's a shipping manifest? What's a bill of lading? Or obligation of any security therefore in which such enemy or ally of the enemy had, or any security therefore in which such enemy or ally of the enemy had any right or interest. Rights, titles, and interest, right? General tangibles, general intangibles, that may have come into the possession of the alien property custodian, with like effect as if he or they, respectively, were duly appointed by the enemy or ally of the enemy, creditor or obligee. The president shall issue to every person so appointed a certificate. The president shall issue to every person so appointed a certificate. Didn't we just learn today that the commander-in-chief operates under the executive branch? And as the president of the United States, he operates in the legislative branch and is subject to the Congress of the United States, right? The president shall issue to every person so appointed a certificate. How does the president have the power to issue certificates from the legislative branch? He doesn't. That can only come from the executive branch under the War Powers, under the Trading with the Enemy Act, the trust indenture of how they're going to navigate this war, the warfare on the land, the hostile military coup and takeover, subjecting you to martial law, of the appointment and authority of such person, and such certificate shall be received in evidence in all courts within the United States. Holy fuck me running. The president shall issue to every person so appointed a certificate of the appointment and authority of such person, and such certificate shall be received in evidence in all courts within the United States. Are you telling me that when parents leave the Foundling Hospital and refuse to give a name and get a birth certificate, that the reason they're being thrown in jail is because the president has issued to every person so appointed a certificate of appointment and authority of such person, and such certificate shall be received in evidence in all courts within the United States, whenever any such certificate of authority shall be offered to any registrar, chief probate officer, clerk, holy shit, clerk of the court, clerk of the bank, or other recording officer, federal or otherwise. Remember, that which is not included is wholly excluded, but when they use a blanket statement such as otherwise, that means everything, because everything is registered with the Secretary of State, because everything is a product of the United States.
With love, Jew.
Within the United States, such officers shall record the same in like manner as power of motherfucking attorney, making me the attorney in fact, because I am the holder. So does the DA, where's his power of attorney? Where's his delegation of authority? Where's his letter of appointment or grant of assignment to charge up the Social Security juristic person and attach himself to the decedent estate? Now, do you understand why the birth certificate's so powerful?
The county that I'm in, the district attorney is actually on the board of trustees for the hospital.
Now check this out. And such record or a duly certified authenticated copyright, duly certified copy thereof shall be received in evidence in all courts of the United States. Remember, they're all Article 1, Section 8, Clause 9, administering a bankruptcy, and they're all excise tax courts. They're all tax courts. All courts of the United States or other courts within the United States. Power of attorney. So there's your evidence that you are wholly distinguished and separate from the thing that they're administering in maritime admiralty in rem, that they're trying to get you to be surety for. And you hold the indemnification certificate, the full acquittance and discharge. And so that's how you can go after the DA. How is he administering an estate without a delegation of authority, a letter of appointment, grant of assignment, or power of attorney? And the reason that I'm showing you this is because of this. 1 second. Just in case you guys think I'm fucking nuts, which I don't blame you. I mean, who else on this God's green earth spends day and night reading
We don't think you're nuts. We know you are.
Yeah. Who else would read this mundane shit day and night over and over and over again? Wait 1 second. I'm going to share something very cool with you guys to put 40 statute at large 411 section 7E into perspective. Why is it not showing up? Because I know for a fucking fact I emailed that to myself. Is that how many people have been emailing me all day? Holy shish kebabs. Okay, let me do it this way. There we go. Ah, there we are. Wunderbar. All right, you guys ready? Boop. This is why somebody earlier said a certificate, a traffic certificate is not a security. It's an unregistered security, and they're absolutely getting an advance on it. And I'm gonna prove it to you right here. So this is Title 28, United States Code, Federal Rules of Civil Procedure, and Supplemental Rules for Admiralty or Maritime Claims and Asset Forfeiture Actions. Okay, they're trying to get you to abandon your property and forfeit your assets. That citation they got an advance from, because as I instructed before, all of those statute, code, city ordinances, rules, and regulations are bonded through the penal code. So each one of them has a value associated with it. Okay. And when they get the advance, they're supposed to give you the advance they got and received from the Treasury, and they are only entitled to a transaction fee because they're nothing more than bankers. They're not actually legitimate government. What they are is glorified securities intermediaries and pawnbrokers who are robbing you and stealing from you. Can you see my screen? You guys can see the supplemental rules for admiralty or maritime claims and asset forfeiture actions?
Yes, sir.
Okay, wonderful. All right, and the reason that this is important is because, again, Article 1, Section 8, what are they in charge of again? Militaries, forts, arsenals, the rules for commerce, and the rules governing the naval warfare and militaries, fort, arsenals, and bases, right? So they're in charge of maritime admiralty, which is underneath the law of merchant and mercantile, yeah? Which goes hand in hand with the excise tax and everything else that they're doing. So, to unjustly enrich themselves and participate in an artifice and a scheme that they have going on, I don't know if that's going to let me do that or not. Let's try it. Go. This is what they did to incentivize the counties to subject you to these statutes, codes, city ordinances, rules, and regulations for which you entered into a contract to, and they proclaim it's a benefit to you, and therefore you're subject to their code because they're extending a benefit to you in the guise of, under the guise of safety that they call law, and demand that it's mandatory or they're going to harass, badger, and intimidate you. That's not it. That's B. District, required affidavit, blah, 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 blah. Complaint may contain a prayer for process of attachment. Where did it go? E. The plaintiff may invoke state law remedies under Rule 64 for seizure of person or property for the purposes of securing satisfaction of the judgment. That's not what I'm looking for. Give me 1 second here, guys. Where did it go? Complaint. Might take a second to find it here. Notice to defendant. No defendant judgment may be entered except upon proof, which may be by affidavit that the complaint summons or process. That's not it. I think it's section E. Answer. Garnishee shall This is all dealing with insurance and assurance underneath the bankruptcy. This is all dealing with the public side of things, and your right to recoupment is on the private side. See, these are your security intermediaries, so you don't have to touch the public. They're supposed to be negotiating it for you, and they are negotiating it for you, but then they're holding it in abeyance in a discretionary trust, and then they come back pretending to be the qualified heirs. And so the judge, the clerk of the court, and the district attorney are engaged in money laundering, tax evasion, unregistered United States securities fraud, also identity theft. There's a whole litany of shit they're doing.
Uttering false securities.
When you learn this stuff, this is when they start to get nervous as a whore in church, and their asshole gets as tight as a wood duck in fucking class 5 hurricane. Let me find it, because it tells you exactly what you're supposed to do. Where did it go? Where did it go? Go. Gosh, it's been so long since I have looked at this. It's either Rule E. I don't want to miss it. It's very important, because it tells you how committee notes on rules. We'll see. In rem actions, special provisions. When available, an action in rem, which is what they're doing in Maritime Admiralty under Article 1, Section 8, Clause 9, these are in rem proceedings, be brought to enforce any maritime lien. This is what they're doing in the public. They're doing liens, okay? Insurance and assurances and placing liens without having a contract in place and without having your express written consent. They're putting liens, and they don't have the SSA 89. They don't have the Form 56, Form 56F. They don't have They're SF61, SF61B. They're not independently bonded under Title 26, 2032 AE11. B, whenever a statute of the United States provides for a maritime action in rem or a proceeding analogous thereto, except as otherwise provided by law, a party who may proceed in rem may also, or in the alternative, proceed in personam against any person who may be liable. That district attorney is liable. Statutory provisions exempting vessels or other property owned or possessed by or operated by or for the United States from arrest or seizure are not affected by this rule. When a statute so provides, an action against the United States or an instrumentality thereof may proceed in rem principles. Complaint in an action in rem, the complaint must be verified. This is why you're demanding the verified complaint. You don't have to say verified criminal complaint because that extra word criminal might throw it off. All right. You want the verified complaint. B, describe with reasonable particularity the property that is the subject of the action. And C, state the property is within the district or will be within the district while the action is pending. 3, judicial authorization and process. Arrest warrant. The court must review the complaint and any supporting papers. Now remember, this is why you have the right to be at the probable cause hearing. Because why? How would you know whether or not the fucking complaint is verified? Arrest warrant. The court must review the complaint and any supporting papers. Now, what they're talking about when they say the court must review, they're talking about the clerk of the court. She's the teller. She's the whole ball of wax. And in most places, she's the magistrate. She's the magi. She fucks around with the words and the lingo and makes everything happen and does the transactions. The court must review the complaint and any supporting papers. If the conditions for an in rem action appear to exist, the court must issue an order directing the clerk to issue a warrant for the arrest of the vessel or other property that is the subject of the action. Ladies and gentlemen, when they issued a guy I know a warrant, they issued a warrant for his juristic person, and they showed up, knocked on the door, and he literally reached into his back pocket, handed him the driver's license, and they go, "What's that?" He goes, "You're now in custody of Aaron James Bethel." And they're like, "No, put your hands behind your back." He goes, "I'm not putting my hands behind your back. You better go talk to your superior, and you better call the attorney and the attorney general, the district attorney. You are in constructive possession of who that warrant was issued for. And that warrant is issued for a person, not for me. So here you go." And he surrendered the driver's license, and they both kind of looked at each other real stupid like, and one of them must have had some training because they just got back in their fucking squad car and drove off. No bullshit. Pay attention. The court must review the complaint and any supporting papers if the condition for an in rem action appears to exist. The court must issue an order directing the clerk to issue a warrant for the arrest of the vessel. Didn't I just tell you that the birth estate is a United States vessel and the evidence of the deed to that vessel is, in fact, the birth certificate or other property that is the subject of the action? If the plaintiff or plaintiff's attorney certifies the extingent circumstances make court review impracticable, the clerk must promptly issue a summons and a warrant for the arrest of the vessel or other property that is the subject of the action. The plaintiff has the burden in any post-arrest hearing under Rule E4F to show that extingent circumstances existed. Now remember, why am I showing you this? Because there is no judiciary. They're operating under Article 1, Section 8, Clause 9, which means these are all special star chamber venues in maritime admiralty jurisdiction under Article 1, Section 8, Clause 9 in the attempt to collect an excise tax. B, services. If the property that is the subject of the action is a vessel or tangible property on board a vessel, the warrant, remember, your birth estate doesn't have any value. It holds value. A receipt is evidence of value being held. if the property is the subject of the action, is a vessel or tangible property on board a vessel. They're talking about your birth estate. See, they charged up your Social Security juristic person, which is a transmitting utility. The problem with that is they need you to authorize the release of credits. They need your signature. They need your authorization. Why? Because 40 Statute Large 411 Section 7E says that you are, in fact, the attorney. In fact, you do have in your constructive possession power of attorney. The warrant and any supplemental process must be delivered to the marshal for services. If the property that is the subject of the action is other property, tangible or intangible, the warrant and any supplemental process must be delivered to a person or organization authorized to enforce it, who may be a marshal, B, someone under contract with the United States, C, someone specially appointed by the court for that purpose, or D, in an action brought by the United States, any officer or employee of the United States. C, deposit in court. If the property, you remember when you called yourself a U.S. citizen on one of them stupid ass forms and you decided to fill out voter registration form and now you're presumed and assumed to be an employee or an officer of the United States? C, deposit in court if the property that is the subject of the action consists in whole or in part of freight, the proceeds of property sold, or other intangible property, the clerk must issue, in addition to the warrant, a summons directing any person controlling the property to show cause why it should not be deposited in court to abide the judgment. Supplemental process. The clerk may, upon application, issue supplemental process to enforce the court's order without further court orders. Remember when it says you must appear on or before? This is what they're talking about right here. They're talking about you going and negotiating with the clerk your tangible, general tangible, and general intangibles. All right, that complaint security and that citation generated the ability for them to make a draw and get an advance from the Treasury, and they want you to release the credits. Now you can go and negotiate because they engaged in securities fraud, and that citation is evidence of their credit liability due and owing to you because they're now saying a debt exists. And if a debt exists and they're saying that they're trying to enforce a debt and they're trying to get the debt satisfied, right? So that's why I need the true bill, because without a true bill due and owing, a debt can't possibly exist. So produce me with the true bill, right? Which is a grand jury indictment. But see, these little rat weasel bastards are masquerading around as managers of your estate. They're making unauthorized transactions to get advances from the Treasury predicated on the presumption and assumption that you are subject to the legislative edicts that exist in the 10 square mile area of Washington, D.C., the District of Columbia, and the federal territories.
Are they not executors de some tort?
Absolutely. And then the atrocity of all of this is they come in as the qualified heir on the backside.
Derrick, I love you. I can't even believe what I'm sitting here watching.
Number 4, and this is
Oh my
why
God.
when you get a hold of FinCEN, the IRS, and you start fucking squawking and talking about securities fraud, and you demanded a W-9, and they're not producing it, and they're saying there's a debt. Well, in order to be a debt, the Secretary of the Treasury can demand the books at any point in time. The IRS can demand the books at any point in time. FinCEN can demand the books at any point in any time. The Attorney General and the Solicitor General, as soon as they figure out what the fuck you're doing, the Solicitor General of the county and the city will quickly come to terms with you, because the last thing they want you to do is fuck up their little fiefdom. 4, notice. No notice other than the execution of process is required when the property that is the subject of the action has been released under Rule 5E. Released to who? Released to who? No notice other than execution of process is required when the property, what property are they talking about, that is the subject of the action has been released under Rule E5. See? The debt that they're alleging that you owe is their credit liability, and they're trying to get you to waive your interest in the funds they have so they can claim it as a Class 5 gift and estate, or they can reinvest it because while it's in motion, it's a commodity, and while it's in motion, it's a commodity. And the second it stops and lands into an account, it becomes fungible funds again, which is a taxable event.
It's tied to a futures contract too for performing.
Absolutely.
Yep.
Yeah.
So the second you sign off, they fucking whoop, send it away, and you never are the wiser to it, and they come back and claim it in 12 months as abandoned property. They're the only organization that can do it in 12 months. Everybody else has to wait 36 months, 3 years.
Accelerated.
The alleged courts are the only ones that can make claims on abandoned property in 12 months. Where's the equal protection of the law? Did they fail to disclose a material fact like the nature and cause of why we're here? Fucking
Absolutely.
right they did. Is that an act of concealment?
All titles vested in the state, isn't it?
Mm-hmm. But which state? This state or the state?
Or whether you lie
Because in
and
the 10th
state.
Amendment, it's the state or the people, right? If I'm the accredited investor, the money you make off my money is my money. And because you failed to disclose material facts, charged up the estate, got an advance from the Treasury, fuck you, pay me. And we'll put on that 1099-A that you already filled out and signed off on it without my express written consent. Instead of me doing a correction and checking box 5, making them liable for repayment, proving that they engaged in securities fraud, we'll just call it a draw and you just go ahead and give me my fucking check.
Yeah, the fiction,
Wow.
the debtor's lying in state. They resurrect the fiction, the dead thing, in a ongoing proceeding where you look up to a judge who's taken 3 steps up, and then they get you to abandon the property. Then they file the 1099-As.
So they got my debits
Yep.
by making an unauthorized transaction, and in turn, from this citation and the complaint security, and in turn, they owe me the credits in the form of the debt liability that they're holding, which means they owe me the Federal Reserve notes or the equivalent thereto, which means they're going to cut me a check.
Can I ask a
They
question?
put it on their Schedule A.
Look, you're missing it.
I
Got an advance from the Treasury predicated on the security issued on the side of the road and the complaint security, and I'm going to show you. And the only thing that is in dispute is whether or not you're going to claim the funds they're holding in a discretionary trust in advance. The judge is the trustee. He's holding it. He has plausible deniability because, after all, he didn't lodge and ledger it with the clerk of the court. The DA did. And so here they are holding on to this general tangible or general intangible property, not knowing who it belongs to. And they're looking for somebody to either claim it or pay the fucking taxes.
okay. Can I ask? There was a warrant 3 years ago, and can I claim that? I had the CUSIP number. I have everything on every bit of a court case 3 years ago, and this ties into it perfectly. Well, I'm understanding it now,
Check it
so
out.
I can go back and claim it.
Well, after so many years, it gets swallowed up by the Treasury. But yes, there's still a way in your master file to go back after it. If the property is not released within 14 days after execution, the plaintiff must promptly or within the time that the court allows give public notice of the action and arrest in a newspaper designated by court order and having general circulation in the district, but publication may be terminated if the property is released before publication is completed. The notice must specify the time under Rule C6 to file a statement of interest. See, not too long ago, remember the iron tank, the old unflappable, the Chancellor that I really like? Well, during that whole motorcycle tax evasion bullshit allegation, at the sentencing, you just sat there staring at me like a bullfrog in heat, big old bubbly eyes just looking at me. And he said, he's a man of very few words. And when he does speak, he's very selective. He likes to get a rise out of me because I got a bit of a fucking short temper and a hot head. He looks at me and says, "Do you have something for me?" I said, "Excuse me?" He said, he opens up the case file jacket and he looks at it. He looks back up at me. He says, "You got something that you wish to hand me?" And right away, I flew off my lid. If you think for 1 second I'm going to grant you jurisdiction, because until this point I hadn't granted him jurisdiction. This is my ignorance, of course, not knowing what's transpiring because I haven't delved into this just yet. I hadn't discovered this just yet during that. If you think I'm going to grant you jurisdiction, you got another thing coming. And he lets me simmer down a little bit. He's not threatening me or nothing. The news media is there and everything else. But he's asking me in front of them if I have something for him. When I read this, I realized what the fuck he was talking about. And I was like, oh my gosh, the guy even offered me leave after pushing off sentencing for 90 days to figure it out. He gave me fucking leave of court if I wanted it. And instead, I was like, fuck you. He turns to the prosecutor, who's not there, obviously. And it says, does the state have any recommendation on probation? And I said, if you think for 1 second I'm going to let a fucking lion, looting, painter, piece of shit fucking monkey lord over me while I'm here on this fucking earth, you got another thing coming. I do not accept your offer to contract. It is not mutually beneficial, and I respectfully decline, and I do not consent. And he puts his hand over his microphone real quick. And of course, the peanut gallery, there's quite a few people in there. And he leans over his microphone and goes, I wasn't going to give you probation anyway. And because he's got to give the peanut gallery the impression that he's in control. See, they need you to consent. This is all voluntary because it all deals with excise taxes and administering a bankruptcy. And they're the ones that were actually engaged in the nefarious activity and crime, and alleging that somehow I violated the law and they're treating me as a private in the military or a member of the militia. So I am guilty until proven innocent, not innocent until proven guilty, because I only have, according to their presumption and assumption, privileges and immunities, which they can take any fucking time they feel like it. Because you're a U.S. citizen, you have a residence, you reside at 1235 8th Street, you fucking, what are the other joining factors that they use? You got a driver's license, you got this, that, and the other. So here we are. Time under Rule C6 to file a statement of interest in or right against the seized property and to answer. This rule does not affect the notice requirements in an action to foreclose. Everything is an action to foreclose because everything is mortgaged. See, in the 73rd Congress, First Session, Volume 77, Part 1, all property is vested in the state because everything is mortgaged. A preferred ship mortgage. What's another term and definition for mortgage? Trust. A mortgage is a trust. It's another word for trust. And an action to foreclose. So they're trying to foreclose on you, and you need to foreclose on them. A preferred ship mortgage under 46 USC subsection 31301 ETSEQ as amended. Ancillary process in any action in rem in which process has been served as provided by this rule, if any part of the property that is the subject of the action has not been brought within